On Radio 97, how good is it to have your own lawyer on standby, ready to answer questions for you on the radio? That's what Despina does on a Thursday morning. If you have a question to do with the law and you'd like a bit of a clarification, bit of an idea on which way to head, Despina, happy to answer that for you. The best way to do that is to send the information to us. Just go to the website, radio97.com.au. Up the top there, you'll find a couple of ways to send the info through. Do that, and Despina, happy to answer the question for you on the radio. radio97.com.au.
And this is quite a juicy court case. Despina shed some light on this case about an employer that was found vicariously liable for a sexual assault claim by one employee against another. So no direct involvement with the sexual assault, and the employer was fined $150,000. Despina, can you talk us through what happened in this case?
So it's very important we talk about this case for employers because, as you say, the employer was found to be vicariously liable for sexual harassment and assault, ordered to pay $150,000. Now, this was a recent case in the Fair Work Commission. This could really hurt small to medium businesses, and they really need to listen up because the Fair Work Commission here went into some detail about obviously why the employer was found to be vicariously liable and what they could have done better to avoid this liability. Very important we talk about this case, and as I said, very recent case in the Fair Work Commission. So the employer, as you say, wasn't involved in the sexual harassment and assault. So the employer didn't really know anything that was happening. It was between one employee and another employee, a male and a female employee, and it was in a hair salon in Victoria. So the actual details of the assault and harassment are quite gruesome, ugly, so we don't want to spend too much time I suppose, going into the detail of those. Someone could read the case if they want to, but I can mention some examples. The male employee was making suggestive comments, jokes, and other inappropriate noises, making comments about the female's employees, certain parts of her body, and doing other inappropriate things. It was quite vulgar. It was quite detailed in the case. So there was definitely a finding of sexual harassment. Mm-hmm. Okay. So was the employer vicariously liable? Yes, he was here. Now, what the Fair Work Commission talked about in detail was why the employer was found to be vicariously liable. Now, interestingly, the company, it was seen that the employer did provide everybody with an employee handbook. And in that employee handbook, it contained anti-discrimination, equal opportunity sexual harassment policies. Mm-hmm. Everyone had it made available to them electronically, and it was generally emailed to new employees with their employment contract. So that all sounds good, doesn't it? It sounds like the employer's done the right thing with everyone that starts as an employee, giving them all the documentation. But unfortunately here, with this particular case that happened in the harassment and the assault, what the Fair Work Commission found is that the employer failed to take a number of steps to try and avoid or prevent this from occurring. And also it involved what the employer did once they discovered that this incident occurred in the workplace. So definitely we're going to go through that now. And so the employers can take some important lessons from this case. So the biggest thing that the Fair Work Commission said, it was that even though the employees were given a handbook, and in that handbook it discussed certain policies, etc., there wasn't evidence that the employees actually understood what it meant by sexual harassment and assault, workplace bullying, for example, all of that. There was no evidence to show that the employees actually understood what all of that meant. So in other words, it's not good enough just to give a staff member, well, here's a book, go read it.
Yeah.
Because they won't necessarily go read it. Yeah.
Exactly. So it doesn't mean that they're going to read it, number one. And number two, it doesn't mean that they're actually going to understand what all of this means, what is inappropriate behaviour, what does that look like in the workplace. So there was none of that provided in the actual workplace setting. So, for example, one way to create or gain knowledge that your staff do actually have an understanding is to have them complete a questionnaire. So that was one thing that the Fair Work Commission said. If you had employees complete a questionnaire which you generate, a lot of questions about, what is sexual harassment and bullying, give examples of certain incidents in the workplace, and then have them identify whether it is sexual harassment or bullying or assault in the workplace, then you would read those answers and glean from that whether your staff do actually understand what it means. Mm-hmm. And if they don't, then to give them greater training in the workplace. So the evidence showed that there was only a very rudimentary discussion with the employees early on when they first started about what it means, sexual harassment in the workplace. Mm-hmm. There was no follow-up by the employer. There was no ongoing training with staff on an ongoing basis, meaning every 6 to 12 months, not every week, but every 6 to 12 months, for example, was there ongoing training for staff to make sure that they continued to understand what it meant to have what workplace bullying and sexual harassment and assault looked like in the workplace. So there wasn't anything like that. Also in this case, the employer never really undertook an investigation about the incident, which was a real negative aspect against the employer. Apparently there was CCTV footage. They never reviewed it whatsoever. They never really undertook any proper investigation. And apparently the employee simply said, "I'm sorry," and the employer just accepted that. So there wasn't a warning given to the employee of any kind as part of any investigation conducted, which they didn't really conduct an investigation. So the Fair Work Commission was quite clear about, well, had the employer conducted regular training, had the employer made sure that the employees all understood what it meant for sexual harassment and workplace bullying and what that actually meant in the workplace, had they conducted an investigation, had they looked at CCTV footage, had they given a warning to the employee about their behaviour, that definitely would have gone a long way to preventing or minimising their liability in this case.
Now, Despina, does this case have implications for all size workplaces? So big employers, but also small, mum and dad employees as well?
Well, potentially, yes, absolutely. And I think regardless of the size of your business, every employer should be listening up, and every employer should be thinking about what can they do better in their current workplace to prevent sexual harassment, sexual assault, workplace bullying. So it is definitely not enough to give an employee a handbook and then don't talk about it ever again, because not only are you not continuing to enhance the knowledge of your staff and your employees, but you're also potentially creating an environment where the employees could take from the employer that, oh, well, you really don't care about workplace bullying, sexual harassment, because you don't really ever talk about it. And I think that if you don't create that culture in your workplace, then you're setting yourself up for potentially this type of incident where you're given a court order to pay very hefty damages.
Very good point there, Despina. Thank you so much for joining us once again on Thursday Morning Talking Law. If anyone does want to get in touch with you directly, where can they go?
So they can phone the office 55291 294, or they can email info@prialalegal.com.au, and I will upload these segments on YouTube this week.
All you have to do is jump on YouTube and search Priala Legal, Priala. Thank you again, Despina and Wayne.
We'll talk to you next week.
Great, guys. See you then.